prejudicial evidence that we believe was elicited improperly, either by introduction of evidence that could not be authenticated or through the leading questions of the government or the state. And the court denied the motion on the basis that there was not sufficient prejudice, essentially, to do so. What I wanted to do was to highlight and make a motion to strike the evidence that was elicited, to be accompanied by a jury instruction, essentially letting the jury know that evidence that's excluded and the evidentiary rules are in place to ensure that only properly authenticated and reliable evidence is put before them, and that's the reason for the rules. And when evidence is put before them that do not comport with the rules, it's because it has been determined under the rules to be either unreliable or insufficiently authenticated. The specific items which I was able to identify by recollection that were introduced and ought not have been in the manner that it was done include but are not limited to the following. And we move to strike it from the record. Any and all phone numbers that were contained in any document Holmes was
Well, you're not talking about physical evidence that's been marked, something that's marked for evidence. You're talking about her testimony.
Both.
What was marked in that? Why don't we do this? Why don't you put it in writing, all right? File your motion, put it in writing, give State a chance to digest it, look at it, and I'll take a look at it, and we can get back, we can have a hearing on it. This just picking out certain, this, she said this or that, I don't know. Typically I rule on objections as they come. So, and I thought I ruled on everything, all the objections. If there's something that's in evidence that you're seeking to me that's already been admitted, that you want to strike and have excluded from evidence, I'm more than happy to talk to you about it and more than happy to listen to your arguments. But I think I need to have something to digest it. So why don't you put it in writing, give everybody a chance to look at it, and do some research on it and find out what the law is. I don't know what the law is on that.
On striking inadmissible evidence?
No, the law on having something that's in evidence removed from evidence. Something the jury already saw.
One
you
thing,
put it in writing.
I understand. One thing, Your Honor, we have another court reporter now, and I think if we're going to put it in writing, it should be complete enough, and we would need a transcript of Ms. Holmes' testimony so that we can be sure to identify all offending references.
I'm sure you can order that, and I'm sure
I think she's out for the week, is she?
My understanding is that she had a calling from a higher authority.
Okay.
Fourth DCA is looking for transcripts.
I thought there was no higher.
Fourth DCA is looking for transcripts, and that's what my understanding she's working on. So you tell her what you need, and I'm sure she'll get it to you.
Okay.
All right. So we'll be in recess. I'm going to make a phone call, and I'll have my Jay make a phone call, find out what the status of the juror is. All right.
Yes, sir. Judge.
We'll be in recess. Counsel, what I'm being told is Juror Campuzano indicated she's still in the hospital. She's on an IV, and she believes that she's dehydrated, and that's they're giving her fluids. She thinks, can't confirm it, that she'll get out sometime today, and she thinks that she'll be here by 1:30, but nothing's definite now, doesn't know. So I wanted you guys to talk it over and let me know what you think.
Yes, sir.
And we'll make a decision.
Yes, sir.
All right.
Thank you, Judge.
We're in recess.
And it's our recommendation that we wait.
State okay with that?
I just have one witness that we might have to adjust a little bit because she's a records concerning her T-Mobile, and she also has an evidentiary hearing. She's appearing virtually on this afternoon. So as long as we can accommodate that, stay fine with it.
You okay with that, Mr. Eggleston?
Yes.
All right, so let's do this then. How about if I tell Gary, just to let the jury know that we had an issue came up. I mean, he's not going to go into any detail, but an issue came up, and we'll see them back at 1:30.
Yes, sir. No
Does that
problem.
work for everybody?
Yes.
Thank you.
All right?
Yes, sir.
All right, just remember, I have one,
Can I go ask the witness really quick on scheduling? So
Sure.
if it's going to fit.
1 second.
Thank you. Yeah, your hearing is at 4, Your Honor, so that'll be fine.
So the state's good with that, defense is good with that, 1:30.
Yes, sir.
Thank you, sir.
All right? You just tell them, be back at 1:30. Thank you.
Thank you.
All right, we'll be in recess.
Turns out to be Y, and we're completely thrown off in the beginning of the case. But I have a moral responsibility when I get in there that I know, no matter how hard the evidence is, that this is the person who did it, and we have done everything to check to see if it was anyone else and to build up that case so that all threads were tied up, if for no other reason that you don't have what the defense attorney did right here with this forensic expert to show that you were malfeasance. The more malfeasance there is, the less confidence the jury has. What are your thoughts?
So exactly right. And as the defense attorney, I'm looking for every single opening that you're going to give me. And there were a lot of openings here in the forensic evidence. There were even openings with their civilian witness, the mother of the girlfriend. There were openings all over the place, and YNW Melly's attorneys are highly skilled. And so they got right into those openings and pointed out all of the inconsistencies, all of the ways in which the evidence is missing and lacking. And that was only cross-examination. Wait until they get to closing arguments and they're able to point out every single opening that was left by the state. All of those openings are reasonable doubt. At least that will be the defense's argument. Does that get them over the finish lines to not guilty or a hung verdict? I don't know, but I do know that it seems like the prosecution left a lot to be desired here so far.
Well, you definitely know things. My producer said you were rather prescient, and in fact, during the course of your answer, you proved that because Felicia Holmes, the mother of the defendant's ex-girlfriend, which you just mentioned, took the stand on Thursday, and there was never a dull moment for sure. Let's take a listen as to why.
Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamell Demons, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it may be about 2016 or so till maybe 2019-20.
Okay. Did you have the opportunity to meet Mr. Demons?
Yes, I did.
What did you refer to him as?
I called him Jamell Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your Honor, may the record reflect an in-court identification of the defendant.
Yes, the record will reflect an in-court identification of the defendant.
So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Have you met her prior to October 26th of 2018?
Yes, I have.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement. Yeah.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, you remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot in that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. But I don't remember what I said at that. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of it. Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement.
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection asked and answered.
Excuse me, overruled.
Ms. Holmes, did you ever say the defendant made you quit your job?
I never really say anything like that. I know it's never made me quit my job.
Objection.
Overruled.
If I may approach him? I'm going to show you this next few minutes. Okay. So I'm going to ask you again, have you ever made a statement that the defendant made you quit your job and that they would take care of us until the trial was over?
I never really say anything like that.
Okay. So you're denying making that statement?
I never really say anything like that.
Okay.
Objection. Your Honor, can I just have a standing objection so we don't keep interrupting?
Now, you stay with your on the standing objection?
Whatever defense is
That's
chooses
fine.
to
Go
proceed. Okay. So, Ms. Holmes, in terms of have you ever said a statement have you ever made a statement to the effect of you were told to quit your job and the defense would take care of us?
Of the judge? No.
Excuse me.
The defense? No.
How much comes out?
Tell me about this one. I can ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about what happened.
Did she tell you what happened? Without
No, she just told she didn't know.
Have you ever made a statement that is different than that?
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Man, I don't know who's more angry, the witness or the defense attorney on that one, but we're going to talk about it with our awesome guests on the other end. Take a break. Please stay with us.
We did get an update from the juror who was in the hospital this morning, and my understanding is she will be joining us. Everything was just, I guess, issue of dehydration or something along those lines, but I'm told she will be here. You hear me all right? All right. One thing, though, I need to bring to your attention is when we broke this morning, one of our jurors, as Gary was escorting the jurors out, he was approached, and one of the jurors had asked him a question. Gary, go ahead. You want to tell us exactly what was said and by whom?
She more or less asked me if she could ask me a question. I said, well, it depends. So the question was, she said, well, what's the status of the mistrial?
So now, I don't know what you want me to do about that, but that's the question that was posed.
Judge, we need to have her knowledge of that, because that was never stated in front of them.
I think it was. I think there was it was done on the record by Mr. Howard the other day. Is Mr. Howard here? No?
No, he's not.
Oh, I apologize. I thought we were all here.
That was all
He's
that-
coming right now, Joe.
Mr. Howard, I'm sorry.
Oh, no problem with it. I heard it all inside the media room. So, no apology necessary. Thank you. Apologize for not being present, sir.
No, it's my
Can't see
fault.
me.
I thought Gary walked in, but what he was advising me and I to the attorneys was that there was a comment by one of the jurors. Did you hear that?
Yes.
So I don't know exactly what you want me to do. Who the juror was?
That was Miss Manuel.
Miss Manuel. So I guess one of the things that is, my recollection, and I could be wrong, is different than yours, Ms. Bradley. My recollection is that there was a motion for mistrial that was made out loud, and Mr. Howard came sidebar. But the jurors been instructed not to read anything about the case. So I don't know if there's something in the newspaper about that. That's a different story, but I don't know what you want me to do, if anything. I bring it to your attention, any real interaction that Gary has with them, something that may seem inappropriate, we always bring it up and let you know.
And should I assume that for future reference, you'd rather I make those motions outside the presence of the jury?
Just come sign.
Okay.
But that was my recollection. I thought you, at one point, I don't know which, there was two motions for mistrial. I don't know at which point, but I believe at least one point you stood up and said, I have a motion for mistrial.
No, actually, there was a question asked. I said objection, move for mistrial, and
No,
you called the
court.
sidebar and asked me to hold it until the end. And then at the end, after the jury left, Mr. Adelstein and I articulated motions for mistrial on an independent basis. And that's how it trended. That's how it went down.
But it was announced in open court, correct?
I said objection, move for mistrial. You called
That's
the
my
sidebar.
recollection.
I remember coming sidebar and that being said in sidebar. I don't recall it being said in open court.
I thought it was said in open court.
It's a fact that I said it.
So again, I don't know what you want me to do, if anything, and, the jurors, is that juror here, by the way?
She's in the reception area.
So, anyway, I'll leave it to your discretion. It was announced in open court, there was a motion for mistrial. Gary obviously didn't answer the question. And, what did you respond, Gary?
I told her I didn't know anything about that. And then she asked me, weren't you there? I said, I don't remember that.
Anyway, that's where we're at. So, you think it over. Let me know if there's any inquiry you want me to make. Madam? Same
Yeah, I
thing, both
think
of
you need to, the state's position would be that she needs to be brought in. Your Honor needs to inquire if she's saying anything in the media or any coverage of that, because that was discussed online, is my understanding.
What do you think, counsel?
Well, to the extent that the court's inquiry of this jury is because of the state's faulty recollection that I didn't say move for mistrial in front of the jury, I know that not to be the case. I did say objection, move for mistrial. You then called the sidebar, and the only thing you said was, please reserve that to the end.
That's my recollection.
Yeah, that's what I...
But again, is that what you're concerned about, or is it concerned about just because it was said that you think I ought to inquire?
Your Honor, I think that it's at defense's peril if we go forward and if they're going to waive any inquiry of this witness, if she's been looking at any of the other items or anything online that defense brought to Your Honor's attention earlier. Because if they thought was laboring under the impression that there was some sort of cessation of trial and then started looking at media and news reports because they thought their jury service was over, that would be a problem.
Better to have more information than less, so we have no objection to that being the procedure that we employ.
So you want me to bring her in, indicate to her that I was advised by our bailiff, Gary, that you asked him a motion for mistrial and what had happened, and just ask her, how is it that you're feel concerned about that, or where did you hear about it? And just find out what information she's got and about it and where she heard it from. Is that the end of the inquiry?
I would ask that you inquire from her if she conveyed any of that to any of the other jurors.
Anything else?
Unless the court wants to say, unfortunately, I denied that.
So we're going to ask what she heard, where she learned it from.
If she did any outside research afterwards.
And if she inquired or asked any of the other jurors concerning that topic.
Anything else that you want me to ask, counsel?
No.
Is there anything else, Dan?
Nothing, sir.
All right. Do me a favor.
He went to get him.
Okay? I don't like it either.
Just for Gary.
Thank you. Ms. Manuel's coming in, counsel. Ms. Manuel's going to come in now.
Okay. Thank you.
Yours, Zachary?
Hey, Ms. Manuel, thanks for coming back in. Let the record reflect the approach of the defendant, his counsel, the assistant state attorneys, as well as one of our jurors, Ms. Manuel. Counsel, please be seated. Ms. Manuel, please be seated. Ms. Manuel, why I brought in is my bailiff indicated to me that when you weren't able to start this morning, that he was escorting the jurors out, and you approached him and asked him about what happened with the mistrial or something to this effect. Is that right? So that's a yes. All right. So I guess my concern is what you may have heard about this alleged mistrial and where you heard it from.
The last day I was here, and the defense attorney jumped up and said mistrial.
Okay. So that's where you heard it from?
Yes.
Anything other than that?
No.
All right. Was there any other research that you may have done or looked at newspapers or any kind of article about the motion for mistrial, anything like that?
No,
Anything on the news, any news media
no.
about the mistrial? No. And last but not least, did you speak with any of the other jurors about the motion for mistrial?
No, when Gary came in and asked us this morning, did we have any issues, any questions? And I didn't want to ask him in front of everybody, so I waited till we got in the hall and I put him to the side and asked him that. If he asked him, he had any concern.
Okay. All right. Okay, that's what we're trying to clear up and find out. Because there's a admonition that I say every time we break, don't discuss the case, don't form any opinion about
No,
the
it was
case.
said in here.
That's what we're trying to find out.
Okay.
Thank you, ma'am. Appreciate it. Thank you. Let the record reflect the juror stepped out. Counsel remain on the defendant. Anything you wish to do regarding this issue with this manual, counsel?
No, sir.
So are we otherwise ready to proceed?
Sure shows up, yes.
I think, are they all here?
As far as I know.
Okay, so see if they're all here. If they're all here, we'll start. Yeah, he did say we're short 2 or 3. 3. But they're here now? They're all here. All right, they're all here now.
This part.
You all ready?
Yo.
Okay, counsel, I'll bring you in. Is that all right?
Yes, sir.
All right, let's put the jury in.